Let's get a break. First, John Day. He's a criminal defense attorney, Santa Fe, New Mexico. Little tedious, this testimony. What's it providing for the prosecution?
Well, thanks for having me, Tim. What this is like, it's like a high school science class where the jurors are listening, maybe trying to understand this. They've never experienced this kind of a lecture before. The jurors generally look at witnesses, expert witnesses like forensic anthropologists, as neutral. Of course, this is a witness for the prosecution. The jurors don't really know what this information means. They will plug it in when they're in deliberations during closing by the prosecution, but it is a little dry. This is a pretty good witness, though. This forensic anthropologist knows how to relate to a jury. She knows how to testify about very dry, relatively uninteresting facts, and she's going to try to make it as understandable as possible. But again, it's tough for a jury to digest all this information with charts and numbers and things that they have never seen before. It's like sitting in a high school class that you really want to be somewhere else.
Right, you have to take it. But you're right, she's throwing in, it's like a French nail. She's throwing in the odd example of everyday life to keep people somewhat interested. This case, the sheriff's investigators, detectives, they went too far after the Miranda rights were read. He wanted counsel. He invoked his right to counsel. And now his confession is out, is not coming into this case. Is this an example of how important that that part of the investigation is, and to not be greedy, because here we are, this should be a slam dunk case, but it won't be.
Right, should be a slam dunk case for the prosecution. You know, when the prosecutors understood what had happened, there was a facepalm moment where they thought, oh man, we wish that hadn't happened. Law enforcement, in their view, overstepped. At the end of the day, they have to create a case against this defendant using everything except that information. So they're building a framework of, a scaffold around the missing pieces. But it's a tough one for the defense to claim self-defense, and that this woman lunged at the defendant and forced, basically, in the defense's view, she forced him to shoot her. He had no other choice. Is that going to fly in front of a jury? That's going to be a really tough one.
Yeah, probably not. I think it may not be a slam dunk. It's still a very winnable case by the state of Florida. Let's get a break. When we come back, more testimony out of the state of Florida. Stay with us. All right, let's go back to Florida now for more of the scattered remains murder trial for Daniel Stearns. He's the defendant. Deputies say that he burned and dismembered Nancy Howery, a woman he was dating at the time. After burning the body, investigators say he took the charred remains and scattered them in several locations. Before we go back in, John Day's watching along with us. Is this a case that, because of the confession issues which were thrown out, he can't take the stand, can he? Because then it would open the door? Talk us through that, because normally a self-defense case, which he's alleging, you see the defendant get up there and spin some story. A lot of times no one believes it, but this probably is not going to happen here.
Well, the problem is if you are claiming self-defense, you've got to make that case in front of the jury. Now, the judge has limited and excluded the statements he made to the police, so those aren't going to come in. But that doesn't preclude him, obviously, in a self-defense case. He's got to be the one to say, this is why I acted in self-defense, because otherwise there's no other way to get that really in front of the jury. So it's an unusual situation, but the prosecutors are certainly wishing that the police had not gone that route, or that there had been a different approach. But at the end of the day, you go to trial with what you've got if you're the prosecutor. So it's going to be interesting to see how he threads that needle on the self-defense claim.
Mm-hmm. All right, let's go back in and listen to more about these bone fragments found at the scene. All right, the back and forth between the investigators and this young Amish man, and talking about what happened. John Day's watching along with us. We're just watching the Stearns case in Florida, where there was an issue with the defendant not asking for a lawyer, and they kept going. That ended up being thrown out. What's your take on the point in that interview that Julia was just talking about, where They are trying to explain to him, hey, this is going to be good for you if you tell us the truth. Act like it's kind of like, you know...
confession. Confessional.
It's the only way to get to heaven, basically, is what they're saying. Is that going to be a problem?
Right. I think Julie's point is very well taken. I mean, the police are using that, posing essentially as this is a clergy communication with a parishioner or someone who is seeking, religious supervision, religious guidance. Now, of course, he comes across as very intelligent. He comes across as very articulate. So it's going to be an interesting situation to say, well, they were able to trick him into thinking he was talking in terms of talking to a clergy person, to someone who was a leader in the church, and that's somehow that shouldn't come in because he thought he was protected under, say, a privilege, a clergy privilege. It's an interesting point, but then again, when you listen to how he talks on the tape, he is very articulate. He's very intelligent. You don't get the sense that he is somehow incompetent to understand what's going on. So I think the defense, I think Julie's right, the defense will have a field day with it, but whether it crosses over into a court suppressing it, that remains to be seen.
You mentioned that he is articulate, and I'm thinking about some of the words they're having to explain to him just because he is in the Amish community. So he's not understanding some of the words that are used by police. How much is his ignorance of, say, certain customs or rules? We know ignorance of the law is not a defense, but he may have a complete ignorance of just some of the mechanics here in this situation.
Right. Well, that's why this is so riveting. I mean, we're getting an insight into a world that most of us don't know anything about. We've only seen on movies or television shows. And so, while he comes across, he's using English words. He's using, words that show that he has a comprehension of what's going on around him. And he seems very intelligent. At the same time, the defense has got to delve into that and say, look, this is an entirely different world that we're getting into. This is something that most of us don't know anything about. And so in his mind, what he's saying to the police is very different than, say, someone who's, Pennsylvania Dutch is not his first language, something like that. So that's what makes this so fascinating, to sort of get an insight into the mind of someone accused of murder who is talking to the police, making statements to the police, and the police are trying to get this confession out of him. But it's like, Mars and Venus, two different worlds talking to each other. And whether the defense can make something of that, that's going to be fascinating.
Yeah, two different worlds, for sure, is how it seems like. John, stand by. We're going to get into more of this. And we're also going to see some body camera footage of the defendant being asked to give that DNA sample that they were asking him about, making sure he even understood what a Q-tip is. That's next.
John Day still with us. There's a lot of back and forth with, do you understand this? No. Do you understand that? No. Is the defense making any headway here with their overall goal of getting this thrown out?
Well, they're doing what they have to do, and they're doing the best they can. But it's a tough one because, again, the defendant is articulate. The defendant seems intelligent. And for the defense to cross that threshold, they're going to have to convince this judge that the defendant was hoodwinked, was scammed into thinking that by talking to law enforcement, it was the equivalent of a religious confession or a religious encounter with clergy, for example. And that's going to be a tough threshold. And it's going to be very difficult for the defense to do what they're trying to do, but that's what they have to try.
What do you think about this statement, John, that he made during his confession? We don't know if it's going to be in or out, but he said, I wasn't in my right mind. I don't even remember exactly how she died. He admits to the suffocation, but he says it a couple of times. I wasn't in my right mind. Do you think that that's an avenue here for the defense if they can't keep this confession out?
Well, it cuts both ways because it shows some comprehension of what's a right mind and what's not a right mind. And so if you're the prosecution, you can pounce on that and say, well, what are you trying to say here? What's your point? But of course, the defense has to use what they've got to try to save this defendant. And by having him say, oh, well, I wasn't that my right. I know the difference between my right mind and what's not my right mind. And in this case, I wasn't in my right mind. But at the same time, he's able to articulate the facts that led up to the suffocation, to the act of what he calls breeding. So, I mean, again, it's riveting testimony. It's riveting evidence from his statement to police Whether it has the effect of saving him, of getting this statement thrown out, in the final analysis, this is going to be fascinating to see where it goes.
Absolutely. John Day, as always, thank you for your valuable time on this Monday as we kick off another busy week here at Court TV. We'll get a break. When we come back, more from the defendants in this pretrial hearing for Samuel Hochstetler.